So my name is Leslie Scarden. I am on the board of the League of Women Voters of the Charleston area and our Director of Good Governance and Ethics. And we are just so thrilled to have such a huge crowd for our first event of our Good Governance Symposium. Tonight, we will be focused on voting rights, which is absolutely fundamental to this series and so much of what we do. We're thrilled to have a slightly different model for this series where we are collaborating with organizations across the state of South Carolina. So one of the benefits of being virtual is we're able to have speakers from across the country join us tonight and have partners across the state be a part of this. So a quick thank you to the League of Women Voters of South Carolina, and then also some of our local chapters who are collaborators, including the leagues from Clemson, Columbia, Greenville, Hilton Head, and Bluffton, Spartanburg, and of course the Charleston League as well. We also want to thank the College of Charleston Political Science Department, Women in Leadership, the Berkeley Chamber of Commerce, the NAACP Legal Defense Fund, which we'll talk a lot about tonight, the South Carolina ACLU, the South Carolina Commission for Minority Affairs, the South Carolina Interfaith Power and Light and Sustaining Way as well. So we're very grateful to our collaborators. I think this really shows how much momentum there is around this. I also want to thank our league members from across the state, but specifically also a few of our Charleston members, of course, Barbara Griffin, Barbara Zia, Shayna Howe, Sarah, Kirsten, Leah, Joan, and many others who have helped make this series possible and who will kick us off. So we're absolutely thrilled to be launching this series. Just a quick overview of what we're doing. There will be 5 different events over the course of the next 2.5 months. Each event has a selection of pre-reads, which we have curated, and these are everything from short articles to podcasts to books to documentaries to really help supplement the content that you're going to hear tonight. So if you want to read more information, find out more, the pre-reads were sent out in that Eventbrite link and registration, and they will also be on the League's webpage. Each event will also have a call to action. So we will be talking about a lot of great information tonight, but we also want to make sure that we take this momentum and harness it. And so we have an incredible panel that's going to talk about what we can do as a result of some of our learnings here. You'll see that our next event is scheduled for March 22nd on redistricting, so stay tuned. If you would like more information about the series, just Google League of Charleston, the League of Women Voters of the Charleston area, and sign up for our newsletter. So before I turn it over to our amazing speakers, I want to talk a little bit about the impetus for this series. When you think about the building blocks of our democracy, what makes this system of government work, what makes progress possible in America, what allows us to pass legislation on education and healthcare and climate change, it comes down to our systems and our institutions. Specifically our voting and election systems, how we draw our districts, the laws we have that monitor money and politics and ethics. That's why this nonpartisan symposium is so critical. And I want to emphasize that this is nonpartisan. These aren't issues that just impact Democrats or Republicans. These are American issues. And if you care about any topic outside of this, education, healthcare, affordable housing, it can be tied back to the 5 core topics that we're exploring throughout the next couple months. Voting rights, redistricting, electoral college reform and how our US Senate works, dark money and campaign finance, and voting and election systems and approaches. The goal behind this symposium is really to help provide the context and history to paint the picture of how we got to where we are today, to speak truth and shed light on some of the history, the bad parts too, but also look at the hope and provide solutions and a path forward. There are definitely proposals and legislation that can address the system and the inequities that we face. And so we believe that there is a lot of learning to do, but there's also a lot of hope. So with that, I do want to plug our book club. This event will have a corresponding book club on Saturday at 1:30. You can go to lwvcharleston.org to sign up if you want to continue the conversation. But you all are not here to listen to me, so I am absolutely thrilled to introduce our keynote speaker, Leah Aden. Leah is the Deputy Director of Litigation at the NAACP Legal Defense and Educational Fund. She was a member of the LDS litigation team and Shelby versus Holder, which we'll talk more about tonight. She's led the LDF's efforts to block discriminatory voting changes to early voting and polling places. She's tried cases in South Carolina, including a case against photo ID laws, and she has many more incredible qualifications. So we'll hear from Leah first for about 30 minutes, and then we'll swap over to our panel with Susan Dunn and Lynn Teague, and I'll introduce them when we're there. But again, please remember you can submit questions through the chat. Please stay on mute, and we look forward to diving in. So Leah, you want to come off mute and put on your video. We can dive right in.
I'm on video. Can anyone see me? And can everyone hear me okay?
Yes. We can hear you, and we are going to spotlight your video so you are at the top of the bar.
Wonderful. Thank you. And good evening to everyone. It's amazing to have this participation, and I'm very, very thankful for the invitation to participate from the League, especially from Leslie and Barbara and the other members of the team who have organized the first of what appears to be a very important and thorough symposium. Tonight, I am going to take the time to focus my remarks on some of the history that should inform where we are today and our political system, some of the challenges that we face at all levels of government, at all phases of our political process, in exercising the right to vote. And last but not least, to not be a Debbie Downer, to also talk a little bit about what we can do in order to ensure a fair and non-discriminatory political process, though I know that my fellow panelists are also going to provide some marching orders for us and their comments as well. To set the stage for my comments, I just want to make clear that from my view, until we can all vote and cast meaningful ballots, then we all truly cannot be free. And it should be the goal that all people can live freely in this country and in our world. And if we're operating from that same perspective, then we're all moving in the same and correct direction. Next slide, please. The Supreme Court, at least in theory, has long recognized that voting is a fundamental right, a fundamental political right that is preservative of all the rights, and from all the other rights flow the right to vote. And as you can see, the right to vote is contemplated in various constitutional amendments. Next slide. However, for but a very brief exceptional period in the era of Reconstruction in the late 1800s, certain constitutional promises have gone completely unfulfilled for Black people. Various so-called race-neutral and state-sanctioned tools have been used to block Black and other people from participating. Some of the most familiar in our history are the literacy tests, the poll taxes, the property requirements, the 3/5 clause in the Constitution, and much, much more. And from its origin, our country, we should recognize, has always carved out certain groups of people to exclude from the franchise, thereby denying them of the most powerful tool to change the circumstances for themselves and their families. Next slide. As Dr. King's eloquent quote here reflects, we have always known that if all communities had access to the ballot, all of us would have access to power and an opportunity to live freely, to access high quality, non-discriminatory and affordable education, jobs that allow people to support themselves and their families, high quality and non-discriminatory housing and land, clean environments, healthcare, non-discriminatory policing and safe communities, high quality and affordable food, and much, much more. And the point is, we have long understood that it's not just about casting a ballot, but it is about empowering communities, transforming the land, transforming our lives. Next slide. Given the high stakes to transform the land, to live freely, to access the franchise, those efforts have been met with all forms of violence and stratagems to block the vote. For example, on the eve of a November 1920 election, the KKK paraded through Black communities in OC, I may be mispronouncing it, OC in Orange County, Florida, and on a megaphone warned, no, not a single Negro will be permitted to vote. On election day, Black voters seeking to vote were turned away by threats of violence, by their names being absent from the voter registration rolls, or poll workers instructing them to get a notarized documentation that they were indeed registered. And I want you to hear those things because we're going to hear about them today. A KKK massacre ensued, killing Julius Perry, pictured on the left above, after Mose Norman sought judicial intervention to protect Black voters' ability to vote. In 1955, Lamar Smith, a 63-year-old farmer and a World War I veteran, pictured on the right, he was shot dead in a courthouse in Mississippi for urging Black people to vote in a local runoff election. Despite his killing being witnessed by law officials, no one was prosecuted. Of course, there are countless other Lamar Smiths, Julius Perrys, and Mose Normans, ordinary people who made extraordinary sacrifices for themselves and their communities, seeking to vote as citizens and to live freely. Next slide. To be sure, this violence and the stratagems that were perpetuated most commonly without any consequences were done by state actors and private citizens, and they were unrelenting for much of the 19th and 20th centuries. Next slide. Next slide. And the violence and stratagems also occurred in other but no less sinister forms than physical violence. For example, in Fayette County, Tennessee, from 1959 into the early 1970s, many Black residents were evicted from the sharecropper shack housing that had been homes to some families for generations for registering to vote and seeking to participate politically. Several hundred people had to move into 2 tent cities erected on donated land, some living there for more than 2 years. In addition, Black residents who registered to vote were prevented from purchasing goods and services necessary to survive from day to day, such as milk and eggs, fuel, and even medical care. Next slide. So violence in all its forms, from threats and actual physical harm, killings, firing people from their jobs, refusing to pay people for their labor, that is all that precipitated Congress's enactment and President Johnson's signing of the Voting Rights Act of 1965. This legislation is considered perhaps the most important that this country has ever enacted. Next slide. And that is because the Voting Rights Act of 1965, because of it, many Black and other people of color in Wilcox County, Alabama, as pictured here and elsewhere, were able to vote for the first time in their lives. Next slide. The VRA is also responsible for the election of this country's first Black president, as well as thousands of elected officials of color, Black elected officials, Latino elected officials, Asian American elected officials, Native American elected officials at all levels of government nationwide. Next slide. But we also have to always bear in mind that this past has to inform the present, and that whenever the franchise has expanded, it has always, always, always been met with the violence of voter suppression. Next slide. And in this 21st century where we live, we are experiencing great expansions of our franchise, followed by systematic suppression. Next slide. Why is this backlash happening? It is occurring because of the historic levels of participation, from registering to voting, and from people of color running for office and being elected. We are seeing in recent elections the most racially diverse electorate in US history. This backlash is occurring because the decennial censuses and other data are showing that this country is becoming a majority people of color and younger nation. This is a trend we are seeing nationally, and this is what is already the reality in places like Texas. It is no accident that we have seen the recent attacks on the once-a-decade census collection, the attempt to carve out non-citizens and starve the Bureau of the resources it needs to count other hard-to-count populations. This backlash is occurring because the Supreme Court and lower courts are striking down or weakening federal protections, exemplified most notoriously in the 2013 Shelby County decision, which I'll focus on in a bit. And these and other decisions, the federal judiciary is deferring to states to carry out election laws that deny, that burden, that dilute the ability to register, to vote, and to be represented. Based on a 2008 Supreme Court decision, Crawford versus Indiana, we've also seen officials being able to implement many of these stratagems to protect against unproven voter fraud, even without evidence that this so-called fraud is actually occurring in any meaningful way in any jurisdiction in the country. And finally, this backlash is occurring because of the hateful racism, xenophobia, transphobia, and outright lies at the highest level of government under this previous administration that is feeding into the myth that this is a zero-sum game, that there isn't enough in this country for all of us, nor in the world for all of us. Next slide, please. Now, all these realities, and there are just so many, I'm going to focus on this 2013 Shelby County decision. And pictured here are some of LDF's clients who are defending the continued need for the core provision of the Voting Rights Act known as Section 5. Next slide, please. In 2013, the Supreme Court invalidated Section 4B, the coverage provision of the Voting Rights Act. This determined where Section 5 applied. And in so immobilizing section or striking down as unconstitutional Section 4B, the Supreme Court immobilized Section 5. The court stated, no one doubts that voting discrimination still exists. But according to the majority, however, there was a mismatch between where the problem of voting discrimination exists and where Section 5 protections applied. Next slide, please. Okay. Section 4B, as I mentioned, identified the places in the country with the worst histories and ongoing records of voting discrimination. And it required those places under Section 5 to pre-clear any voting change before it could be implemented. It required covered jurisdictions to show the Department of Justice or a 3-judge court in DC that a proposed change wouldn't make the ability of voters of color worse off than the existing system. Any voting change included moving or closing a polling place, annexing voters in or out of a jurisdiction, changing the qualifications of to be eligible as a voter or as a candidate for office, changing the dates of elections, or for purposes of where we're headed, the changing of the boundaries for drawing redistricting lines. Section 5 applied to any voting change. Next slide. This map depicts the 16 states that as of 2006 in whole or part were covered, protected by Section 5 of the Voting Rights Act. And you'll note that South Carolina was among them, as were states primarily in the South, but not exclusively. Next slide, please. The late Justice Ginsburg, in her dissenting opinion in Shelby, said that the majority's decision was like throwing your umbrella out in the rain because of how effective Section 5 had been at blocking some of the worst forms of voter suppression stratagems. With the Shelby decision, we lost significant protections, notice of each and every voting change in those covered jurisdictions, the process by which the public could comment on a proposed change and sound the alarm about how it would harm their community, the ability to stop a change before it went into effect and elections occurred and incumbents could get the benefit of the discriminatory processes. We lost that the Section 5 process put the burden on the jurisdictions with the record, the documented record of systematic racial discrimination in voting to prove otherwise. We lost the deterrent effect of Section 5. Jurisdictions wouldn't even attempt some of the foolishness that we see today because they knew they couldn't satisfy their burden. We lost the relative quickness of the preclearance process as compared, as I'll explain later, to the time that it takes case by case to go after the discrimination. And we lost the relative cheapness for the so-called fiscal conservatives, the relative cheapness of the preclearance process as compared to the costliness of having to bring affirmative litigation in the courts or to drag ourselves to the legislatures day in and day out to try to beat back voter suppression. Next slide, please. This decision has been devastating and responsible for much of the voter suppression that we have seen in the places that Section 5 formally operated, but also in the way that voter suppression has spread like a cancer throughout this country, unrelenting. Next slide, please. Indeed, in light of all these monumental developments, including the Shelby decision, we have seen barriers erected at all phases of the political process, at all levels of government. I tend to think that many of these key barriers, they fall into three major buckets. Next slide, please. The first bucket concerns the limitations on who gets to register and vote. For the most part, if you're 18, if you don't have a felony conviction for reasons that are related to racial discrimination, if you are a citizen, you should have the right to register and vote. Next slide, please. The second bucket concerns, once I'm registered, what hurdles exist for me to access a place to vote? And do I have what I need to receive a ballot? That's the next major bucket. And the third bucket, next slide, please, is once I've managed to be registered, once I've managed to remain on the rolls, once I've managed to access a polling place, once I've managed to have the documentation that's required of me to vote, once I cast my ballot, does my ballot have the same value, the same meaning as the ballots of other people in my community? I'll take each of these in turn. Next slide, please. With respect to felony convictions, our country has erected barriers in the form of felony disfranchisement laws that prevent about 5 million people, disproportionately Black and brown, from being able to vote because of their criminal records. Many of these laws, from Alabama to New York to South Carolina to New Jersey, they were erected in direct response to the abolition of slavery to keep Black men from voting. Legal challenges, and I'll acknowledge that felony disfranchisement laws existed prior to the end of chattel slavery, but they were ramped up for the most part in those states because of the bringing of new citizens into the franchise. Legal challenges, some of which LDF has brought, ACLU has brought, the League has brought in New York, in Washington, in Florida, and other parts of our country, they've been unsuccessful for the most part to strike down these laws. Instead, what we've had to do is to chip away at the edges of these laws, like in New Jersey most recently, allowing certain people to vote when they are no longer incarcerated. I'd be remiss if I didn't mention, however, that Maine and Vermont, these states with overwhelming populations of white voters, people can vote with felony convictions while incarcerated. We're seeing in Florida, whose demographics do not compare to Maine and Vermont, that even when 65% of voters in November 2018, that's more than 5 million people, they voted to restore the voting rights of 1.4 million formerly incarcerated people. The 11th Circuit Court of Appeals, in a case that LDF litigated alongside the ACLU, the Brennan Center, and others, representing the Florida NAACP and the Florida League of Women Voters, that the Court of Appeals permitted the legislature to implement a law that undermines the constitutional amendment that the voters of Florida passed by requiring people to pay sometimes indeterminate amounts before they can get their rights restored. This is a state where, prior to Amendment 4, 1 in 5 Black people were effectively disenfranchised for life because of felony convictions. This is one of the most glaring barriers to the ballot, one of the key civil rights issues of our time. Next slide, please. To the extent one does not have a felony conviction and they manage to register to vote, we are seeing jurisdictions like Georgia and others implement exact match programs whereby those states are beginning to purge people from the voter rolls where their names on their voter registration forms don't match up with exactly what some administrator has typed into a DMV. And these types of laws have disproportionately impacted Black, Latino, Asian American, and other voters. Next slide. We're also seeing states, in terms of access to the ballot, purge voters. the Supreme Court, in fact, in a 2018 decision known as Husted versus A. Philip Randolph Institute, gave the green light for jurisdictions to use voting inactivity for whatever reason someone chooses not to vote as an impetus for the state to remove voters from the rolls. These again have had disproportionate impact on Black, Latino, and other voters. Next slide. Turning to this second bucket, I had managed to be eligible. I had managed to get registered without some mismatch kicking me off the rolls. I had managed to not be purged because I haven't voted for whatever reason. The next bucket involves limitations on early voting, and states have implemented cuts to early voting, despite the fact that we know that Black, Latino, and other voters of color disproportionately use early voting to access the ballot outside of traditional election days, to overcome limitations on their work schedules, their family obligations, on transportation. As a glaring example, Georgia has attempted in successive legislative sessions in 2014, 2016, 2018, and now 2021 to cut back on early voting because Black and Latino voters use that process. Next slide, please. Barriers to early voting have also acutely harmed student voters, where states have been trying to cut back on the ability of students to access on-campus early voting. LDF just came out of a trial where we represent students at the historically Black University in Waller County, Texas, Prairie View ANU, who have been the subject of discrimination for many, many decades. Most recently, it has been the county's attempt to remove early voting on campus. But Waller County is not alone. Florida attempted to cut early voting on campus at any public university. And even when they lost the ability to do that in court, they then tried to set up restrictions on parking to try to limit the access to the ballot. So it's one thing after the other. Next slide. I'll briefly mention that in addition to cuts on early voting, we have seen many, many changes to polling places across the country. And while I note this is because not every polling place change is a problem, but when thousands have occurred, and as of 2020, according to Vice, 21,000 polling places have been eliminated, we lack the ability to scrutinize each of those and their impact on communities. And most importantly, they are very difficult to get at through advocacy because they require so many resources in order to scrutinize the reasons behind the change and the impact on particular communities. But they nonetheless have very, very devastating consequences. Next slide. One example of polling place changes that was beaten back by advocacy and not litigation occurred in Randolph County, Georgia in recent years, where the county attempted to go from 9 polling places to 2, where there was limited transportation, limited public transportation, and where Black voters and other voters suffer from socioeconomic disparities as compared to white voters. It was only because of advocacy, shining the light, making a lot of noise, getting on Rachel Maddow, that the county eventually backed down from attempting to close its polling places. Next slide. The next big question involves access to the proper documentation in order to vote. One of the most recent tactics in order to limit the ability of people to access the ballot has come in the form of strict photo ID laws. And this is a practice that has swept the entire nation. Now, from our vantage, maybe getting an ID isn't a big deal. But if you were born in Jim Crow and you don't have a birth certificate, it can be. If you live in Texas, which these are the IDs that Texas was initially attempting to require. If you live in Texas and the legislature carved out the types of IDs that white voters were likely to have, like handgun licenses, driver's licenses, and prohibited the use of IDs that minority communities are likely to have, like student IDs, government and state IDs, tribal IDs, photo ID laws can be a barrier. if you're a woman who got divorced and your ID doesn't match your name on the voter registration rolls, a photo ID law can be a barrier. ID laws tend to hit Black and other voters of color hardest because Black people are less likely to possess the IDs that legislatures select, because Black people tend to live further away from photo ID issuing offices. Black people have less access to cars and other transportation, and Black voters tend to be poorer than their white counterparts. Texas, like South Carolina and other states, proposed photo ID laws that were initially blocked by the Section 5 process. As many of you know, South Carolina took the Department of Justice to court and ultimately was allowed to implement its photo ID law so long as they provided an exception for people who could not reasonably obtain a photo ID law. Texas, however, only agreed to that sort of carve out for people who could not reasonably obtain IDs after years of litigation. And I would be remiss if I didn't mention that Texas and other states do this in the name of purported voter fraud. But that was the rationale that underlie white primaries in Texas. It was the rationale that underlie the secret provisions, ballot provisions in Texas. It was the rationale that underlined poll taxes. Voter fraud was the rationale that underlined the pre-registration requirements and voter purges in Texas and elsewhere. All of these laws, their actual purpose is racial exclusion and the prevention of voters of color from holding the balance of power in elections. There is absolutely no evidence of voter fraud in any meaningful way. Next slide. I'm going to wrap up shortly. This is just demonstrating the number of voters impacted by ID laws, and you could take a chart like this and apply it to many other states. And when you look at the types of elections that are held when these ID laws are in place and the margin of victory, you can see the direct relationship between these suppressive methods and their impact on elections. Next slide. The last big bucket of voter suppression that is important to mention as we embark on this next round of post-census redistricting is what happens when you're actually able to access the ballot box and cast your ballot. Does your ballot have the same value, the same meaning as those in your community? And what we see is that officials in power often attempt to adopt or maintain redistricting plans that structurally allow them to select their constituents rather than you being able to elect your representatives. This comes in the form of at-large voting structures, racial gerrymandering, partisan gerrymandering, prison-based gerrymandering, malapportionment. I know you're going to be doing a whole seminar on redistricting. I hope you hear more about those, and I hope you take them in because you will see those operating as we move forward with the redistricting cycle. Next slide. And what advocates attempt to do is to create districts or other electoral structures, cumulative voting. Now we're seeing the rise of ranked choice voting, attempts to unpack or uncrack voters of color in districts where their votes are diluted, in large part because these structures interact with racially polarized voting. The fact that in South Carolina, in Louisiana, and Texas, you can still determine the race of a voter still determines how they cast their votes. And oftentimes minority communities and majority communities do not prefer the same candidates. And so when these systems operate with these voting patterns, minority communities' voices are diluted in these structures. And this has been a long stratagem in order to deny and dilute the ability of voters of color to participate. Next slide. Cracking and packing are terms that you'll likely hear, and those will continue to be stratagems to disperse communities of color or pack them together in districts where they cannot coalesce their votes together and allow them to elect candidates of choice, and again, elect representatives who are not just figureheads for them, but who can adopt policies that actually change people's lives. I'm going to conclude by saying that it's, as the next slide reflects, although we have suffered lots of devastation in terms of the tools that are available to us. Leslie, if you could go to the next slide, please. We still have some existing tools, and I raise them because the Voting Rights Act, despite suffering a severe blow to the heart of it with the Shelby County decision, there are still other provisions. Section 2, which allows you to challenge laws after they go into effect. Section 11B, which allows you to get at voter intimidation, which is becoming all the more rampant in recent years. We have constitutional provisions, we have state laws. We should be harnessing all of those. But as I think you'll hear going forward, we need more than these existing tools. We need federal protections. We need the courts to enforce these provisions, in large part because, and you can quickly go through the next 2 slides, Leslie, all of the work of getting at discrimination after the fact takes years. It takes thousands of dollars, millions of dollars in some cases, and oftentimes remnants of the discrimination remain in effect. You can go to the next slide. And the next slide. So I'm going to encourage all of us to use these public education opportunities to understand that the past is present, that what we're seeing today, we have seen in the past, that the rationales that we are hearing today, we have heard about in the past, that we need to shine a light on this because we seriously need states and federal governments to step in and create systemic protections for the rampant voter suppression that is simply too hard to get at on a case-by-case basis. Where we have bodies that are willing to legislate, they should be pushed to also put in place good government changes like automatic voter registration, same-day registration, expanding early voting. They should protect against manipulative redistricting. They should eradicate felony disfranchisement, and we should be calling them all to do that. And in closing, and I mean this in closing, we are called upon in this last slide, according to Dr. Martin Luther King, whose words remain as profound today as they did during his life, that if you can't fly, then you have to run. If you can't run, then you have to walk. If you can't walk, then you have to crawl. But whatever we do, we have to keep moving forward. We owe it to the people who were murdered, who lost jobs, who have been intimidated and exercising, who have overcome hurt and exercising the right to vote. We are a better nation when more of us participate, not when less of us participate. And that has to be what we do in this critical moment and going forward. Thank you very much.
Thank you so much, Leah. That was illuminating. And I know there was a lot of information packed into a very precise presentation. So thank you for that. And up here on the slide, you'll see Leah's contact information. Again, we're going to wait until the end for Q&A, but if you have questions now, please feel free to go ahead and submit them in the chat. We are going to turn to our panel. We have some great context, some great history. We have shed light on some of these huge, huge issues that our country faces. And now we're going to talk about solutions. So I would invite Lynn and Susan, if you can turn your videos on and come off mute. Lynn, I see you. And then I think we're going to go ahead and spotlight your videos. So we have Susan Dunn with us. She is the legal director for the ACLU of South Carolina. She's been with them since 2009 and litigated Ferguson versus Charleston, a groundbreaking Fourth Amendment case that was argued successfully before the Supreme Court and the Fourth Circuit. So Susan knows her stuff. And then we also have Lynn Teague, who is the vice president of Issues and Actions for the League of South Carolina. So Lynn is a true hero of the league. She coordinates statewide policy analysis and advocacy on voting and elections and ethics and judicial selection and the environment and education. And I could go on, but Lynn is our voice in Columbia. And so I'm thrilled to turn it over to them. We're going to do about 15 minutes to talk about our call to action and legislative options and how we can all help. And then we will go to our Q&A. So I'm going to stop sharing my screen and we are going to highlight Lynn and Susan on video. If we can do that. And Susan, are you on? Can you hear me? Perfect. All right. So Susan, our first question is to you. We've heard a lot about HR 1, the For the People Act on the federal level. Can you tell us what this legislation would do specifically when it comes to voting rights?
Well, yes, I can try anyway. H1 is an omnibus bill that has a whole bunch of things. And if I told you about all of them, we'd be here all night. But I do want to highlight the actual, sort of construct of the bill is one in which the federal government sets some guidelines that must be met by the states for federal voting. And the theory is that if you have to do this for the federal voting, then it would make sense to do it all the way around. Just because it would be easier than running two different systems. We don't know if that would really work out, but at least it would be the federal government establishing some baseline for what is required to be a modern, safe, and accessible process of voting. And so this bill includes a whole lot of things, including same-day registration, online registration, automatic registration, and I think people sort of think we have automatic registration in South Carolina already, so that when you change things or sign up for a driver's license or an ID card, you can go ahead and have that information passed on to voter registration, but you have to opt into it. What the H1 would provide was an opt-out. So anybody would automatically, if they register to go to a public college, if they sign up for a license, that information would automatically register for them to vote unless they opted out. But among the other things would be establishing all federal elections to be federal holidays. So it would be you think that's a simple thing to do, but it's never happened before. So having it be a federal holiday is one of the things that they are proposing. They're also it would restrict purging of voters from the voting list. Would put some kind of guardrails on when people can be purged. And it would also make it so that no one would be purged any closer to an election than 6 months. So it would cut down on some of the last minute purges that we've seen in some kind of election manipulations that have happened fairly recently. H1 would also make it so that anyone who had completed a felony conviction could re-register to vote for federal elections. Which is similar to what we have in South Carolina already, but I think making it part of the federal construct would communicate to people who belong to that community that their votes are valuable and that they should be welcomed as full citizens when they've paid their dues to the community. So that's there are a whole lot of other kinds of things in here, including some changes to redistricting that I'm sure you'll hear about in your redistricting conference, and they're all of these things are sort of lumped together. I think it's important for people to know that in the House of Representatives, which has 435 people who get to vote, there are already 225 sponsors of this bill. So we're very positive of movement in the House of Representatives, but those people are still going to need to hear from us that we say that this is very important. So that was running through it, but it's a lot in this bill.
That's great. Thank you, Susan. And then Lynn, on a South Carolina statewide level, I know the League is tracking a number of bills. Can you tell us about a few of the bills that would expand voting rights that we would see as positive for voting rights, and then their chances of passage this session?
Sure. There have been many bills filed that would improve our elections, and some are basically technical improvements in administration, but some would improve access to the vote while preserving election integrity. There are, for example, bills that would permit no excuse early voting, and especially no excuse early voting by mail, which we don't have now in South Carolina. Voters across the political spectrum loved these options when they were made available in 2020 during the pandemic, but I see little hope for them as permanent changes in South Carolina law. Too many legislators are convinced that the measures would be a disadvantage to their party, and some support unfounded claims that voting by mail is subject to massive voter fraud. There's abundant evidence that voting by mail does not produce outcomes that favor either major party and does not enable widespread fraud. However, convincing legislators of this is hard when they have been bombarded by claims to the contrary. There are also bills that would provide automatic or same-day voter registration, already in place in many states. However, a much more modest expansion of voter registration opportunities failed here in 2020. There's little or no hope of passage of that this year. If there's hope for anything, it's a very modest change found in several bills that would require informing those who are incarcerated of the process needed to restore their voting rights, without in any way changing or expanding those rights. On the whole, though, improving voter access is simply not a priority.
I came out, you weren't there. I waited 10 minutes. I walked up to the highway, you didn't come. I said that.
Whoops, somebody wasn't muted. Okay. So anyway, on the whole, improving voter access is simply not a priority of the South Carolina General Assembly.
Lynn, could you speak to some specific bills in South Carolina that we're worried about and their chances of passing when it comes to voting rights?
Sure. Well, first of all, we don't have to worry about some of the bills that have been talked about that would make voting harder in other states because we're already there. We don't have those options. Our greatest concern at present is H 3444, which would have the potential to affect many election practices and policies. The primary intent of this bill is said to be ensuring statewide consistency in interpretation of election law to avoid problems like some that were identified in 2020. Last fall, it was found that absentee ballots that would be rejected in one county might be accepted in others. We know that that should not happen. However, the State Election Commission already has explicit authority in state law to compel counties to follow a consistent interpretation of election law. The differences between counties that were discovered in 2020 were not the product of insufficient SEC authority. Poor communication is more likely as an explanation. So what would this bill actually do? The bill would give the SEC plenary or absolute authority to, quote, supervise and standardize the performance, conduct, and practices of the county boards of elections and voter registration. It would also reconstitute the SEC to add legislative appointees to those currently appointed by the governor. We're concerned that this bill to increase state power over county election offices, which might not be a bad thing in itself, is made problematic by the risk of partisanship and by the expansion of legislative influence. Bill supporters claim that its 2-to-1 ratio in favor of one party in the membership of the SEC is an improvement over the current 4-to-1 ratio. But partisan tensions around election processes have been very high recently, so we do not find this very reassuring. We also do not believe that the SEC is a function in need of legislative appointees. More broadly, we're concerned that there's already a serious disconnect between authority and responsibility in election administration in South Carolina. SEC oversight power over counties has already been expanded, but the state has done nothing to operational or fiscal responsibility consistent with its growing power. This disconnect already has been a source of tension in some counties. County governments have no power over the election offices. They're overseen by county commissions appointed by legislative delegations, but the counties must cover substantial ongoing operational expenses, as well as extraordinary costs, such as attorney's fees when something goes wrong. Then every year at budget time, the General Assembly routinely fails to provide counties the reimbursement they were promised for carrying out those state-dictated responsibilities. This also raises questions about the role of county commissions. Are they even needed? The time to ask that question, and others like it, is now when you're contemplating changing responsibility and authority. We believe that rather than passing this bill, there should be a study committee to thoroughly review the current status of state and county election commissions. The goal should be a system in which the composition of the SEC is one that all voters in South Carolina can have confidence in, whether they're Republicans or Democrats or independents or members of one of the 8 smaller parties recognized in the state. And whatever their number, SEC members should be appointed by the governor. Finally, the system should be one in which the structure at state and county levels and between those levels provides balanced and appropriate allocation of operational and fiscal authority and responsibility. In recent years, both the House and Senate of our General Assembly have had study committees that have produced excellent results, actually, leading to sound legislation on subjects that are complex and of major concern. It is past time to take election administration that seriously.
Great, thank you, Lynn. That's really helpful. Susan, could you talk a little bit about what the ACLU is doing in South Carolina to help protect voter rights?
Well, one is we stand prepared to litigate when we need to. Despite the fact that lawsuits are not everybody's favorite friend, they're an important quiver to have in your arrow. And the ACLU is committed to having those resources available when they're needed. We're also committed to working as hard as we can to make it so that litigation is not needed. When we discover things that are not being done right, for instance, the re-registration of ex-felons is not handled appropriately in South Carolina. We've been raising that question for some time, and we will continue to. And we're beginning to get traction on that. I think people are seeing that it doesn't make any sense for Aiken to do it one way, Greenville to do it another way, and to Charleston do it a completely different way, that there needs to be some consistency there. And just the proof of the lack of consistency and having that information is important. The ACLU also works very hard with other partners to participate in election protection at every election. So we have nonpartisan monitors who are available all across the state to observe what's going on and to report in a systematic fashion what they see, and to get help for voters when they need it in a way that's not buying their vote in any way, but just simply making sure that they're able to vote where they're able to vote if they're eligible to. So we're working on all of those things, but we work with Lynn. You know, I call her up and ask her, what do you need us to do? And when she tells me, we try to respond. So I think that there's, it's really important for all of us to realize that this is an issue where we can't live in silos. And part of what the ACLU does is simply when we're invited in to talk about other issues like LGBT rights or reproductive rights or immigration rights, we always talk about voting rights. That these are not things that can be handled separately. And the whole community conversation in which we are committed to the foundational pieces of democracy are being as important as winning. You know, we have to fight against a system where winning at all costs has become an appropriate matter of doing politics. And that's not a criticism of either party. It's just a way that the whole thing is happening. And there need to be other voices, and we are determined to get the training and the information out there so people can act like citizens and talk to each other like citizens. But it does, we're really talking about something now that requires sort of a cultural change in terms of the conversation. And when we hear something drifting off where you see that it's win at all costs, saying that, that's not something I want to be part of. Let me talk about something else. Let me push you on, how do we ensure that somebody with disabilities has access to the voting rights? Are you working for that? Asking those questions any opportunity we get.
Thank you, Susan. I think that's a great segue to our final question for our panelists before we go to Q&A and bring Leah back in too, which is we've decided to focus our call to action tonight around HR 1 federally and H 3444 in South Carolina. Can you both share with us how people can get involved, how they can make their voices heard? We've talked a lot about judicial options, but what can we as everyday citizens do?
I can start here at the state level. We would love to have people go to communicate, call or write their House members and their senators. The House members are more urgent. You can find the contact information at statehouse.gov and tell them on H 3444 that elections are too important to get wrong. Ask them to establish a study to understand the lines of authority and responsibility and how they can be best designed so that we can all be confident that they will work for secure, accessible elections. Sorry.
Great, thanks, Lynn. And Susan, anything you would say, any advice you can give to us who are, we're going to be calling our representatives? What else can we be doing? How can we be framing those asks?
Well, I think we can also be reaching out to, it doesn't hurt to go ahead and reach out to the senators that may end up being the critical votes. And we know who those are going to be. It's not going to be Senator Graham. It's not likely to be Senator Scott, but Romney, Manchin, Murkowski, Collins are all people who need to hear from as many people as they can. And we may not be their voters, but I think it doesn't hurt to have our voices participate in that. It also it doesn't hurt to reach out to our representatives of the House of Representatives just to let them know that we care about this and we're watching, and that we will remember next election how they vote on this, whether they want our votes, whether they count on our votes. I would mention that HR 1 is such an omnibus bill that there are always going to be people of like minds who disagree on some of the provisions. For instance, the ACLU is very supportive of most of the provisions of HR 1, but have some problems with the Disclosure Act that I didn't talk about tonight. But you may get mixed messages, but that doesn't mean you don't push for the possible. So we work for the possible and still keep trying for the perfect. So you want to be in this conversation, and you want to let them know we're watching what they're doing, and we want them to be supportive of fair and accessible elections.
Fantastic. Thank you both. So we're going to bring Leah Aiden back, and we're going to do about 10 minutes of Q&A, and then we will wrap up for the night. So if you have those questions, please submit them to the chat. Please stay on mute. Don't unmute yourself. Just submit those to the chat. We've had a lot of questions come in on HR 1. So why don't we address some of those first? And I love this first question from Cleo Brown. Since pre-clearance prevented so many problems and Congress can fix the formulas and reinstate pre-clearance, why isn't fixing that at the top of congressional priorities? Could we speak to provisions in HR 1 that would address that?
Leah, do you want to do that one, or do you want me to? Okay. We've actually got a situation where there are two different bills that have been making their way through Congress, and the one that is set up to essentially revitalize the Voting Rights Act had actually been one that was named in the honor of John Lewis. And so that bill is kind of moving a little bit parallel to HR 1. There's some effort to kind of consolidate them, but that hasn't really happened seamlessly yet. So that people do know that the main thrust of HR 1 is simplifying the voting process for the individual voter. The John Lewis Act is more focused on watching systemic problems and making it so that we have the tools that we need to move quickly when those can be identified. So they're slightly different in their focus, but the folks they are working on both of them, and I guess they're trying to weave them together, but it's not clear whether that's going to happen. If I confuse that, Leah, but
no, that's exactly right. I think every legislative cycle since the Shelby County decision, there has been a bill introduced to respond to it. I think there is now more of a recognition that we need it, that we can't kind of go through what 2020 was and the previous years have been, which is one thing after the other. We should remember, though, that the Supreme Court that we will have to live with for the years to come is hostile to federal intervention in state elections. And so there is a strong need to make sure that the legislative process is as fulsome as possible to support a record that would justify Congress stepping in once again and providing these pre-clearance protections. But you should be telling everyone that you know that not only is HR 1 a priority, not only is beating back the state bill that you've heard Lynn and Susan talk about, but HR 4, getting back what we lost in Shelby County, is like right up there with your priorities and what they should be doing if they represent you.
And I think one of the differences is that the things like the online voting and those kinds of things don't require a lot of fact finding on the part of the legislative bodies, but to fix the Voting Rights Act is going to require full-fledged hearings, and it's just going to be a little slower. And I think people kind of don't want to tie the time frame. So it's just it's a question of what we can get through as quick as possible without ignoring any of the other problems.
That's great. And you all had read the tea leaves, because the next question was about the John Lewis Voting Rights Act. So I think we've talked about how these are really symbiotic bills. One other question around HR 1 that came through, and I like this in terms of clear logistics, in terms of policy, but also more broadly speaking. Will HR 1 take care of the discriminatory voting methods that we've talked about tonight? And Leah, I'm hoping you could speak to that in terms of the nuts and bolts of legislation, but then also speak more broadly around what we as citizens need to continue to do to knock down these discriminatory methods beyond legislation.
So yeah, I would just reinforce that it is I can't even tell you how many pages the HR 1 is. Susan probably knows. She gave you a snapshot at some of the key provisions, but there are a host of them. So they are meant to codify expanded no excuse absentee balloting. They are meant to provide same-day registration, automatic voter registration, expansions on early voting. It tries to address campaign finance. I mean, it really runs the gamut of the buckets that I try to give you examples of and more. And so that is why we should, that is to Susan's point, maybe you don't agree with everything, but we need much of what is in that bill, and moving it forward in the legislative process has to happen, because we can't keep up with all of the different things that voters have to accomplish in order to access the ballot. It's like running a relay race, and people keep throwing up barriers that you have to jump over, and we can't sustain it. And I would like to note the things that we can be doing, because I think there's so much, especially as we head into redistricting. And I know you're going to have a whole panel on redistricting, but we have to, in the same way you're calling your legislative members, state and federal, about these bills, we have to be in the rooms of our city council meetings, of our county commission meetings, of our school board meetings, in the legislative cycle when they are considering the maps. And I know that there are systems in place that entrench power and that allow people to manipulate voting, no matter how you cast your ballot. But we need to be in the room to bring sunshine, to offer alternatives, to build a record so that we can take some things to court when we need to, but also so that we can try to influence as much as possible when those decisions are being made. We're not going to get everything at once, and we're not going to get everything immediately, but this being in the room, pushing back on what people are trying to ram through under cover of night without people participating, we at minimum owe it to ourselves and the communities that we care about to do that, because once people are elected into office under those maps, they will become incumbents. They will likely stay in those seats, and they will enact policies that advantage them and not the communities that they're supposed to be serving. So I love folks to think about how they're going to be engaged in redistricting. I know you have experts helping you. I know you have lawyers helping you. I know but there is a lot of planning to be done, and that's, to me, should be a key focus going forward.
That's great. Thank you, Leah. We've had a couple more questions come in around advocating for HR 1, since we feel pretty confident it will pass the House. And to Susan's point, our South Carolina U.S. senators probably aren't going to be the swing vote in the Senate. So Julia had a great question here. Other than writing a paper letter, how can we reach senators other than those who directly represent us? How do we have a voice in the U.S. Senate to advocate for this?
Well, it's always difficult, but not impossible. I think that a handwritten letter to somebody has the possibility of getting their attention, and I keep doing it. I encourage people to do it, and the swing voters are going to know that they're voting for more than just their state. The senators, you should not underestimate the expansiveness of a senatorial ego. So they're not quite as did you vote for me as the South Carolina House of Representatives are. So I wouldn't underestimate it, because it has the possibility to make a difference.
Great. We had a question come in from Kirsten, which is, Leah, going back to your three branches of voter disenfranchisement and talking about some of our systems, and once you finally get registered, once you get to the polls, does your vote actually count in terms of redistricting? How would you say other systems and institutions like the Electoral College versus a popular vote pact versus ranked choice voting, how do those alternatives influence how our votes count?
I think you guys are having a whole panel on that with experts. So I can't even deign to know, except that I know that there have been lawsuits brought to challenge it. The Electoral College in favor of the popular vote, and some of the arguments tee up the history of the Electoral College. It's rooted in racial discrimination. My organization has staked out whether, as an alternative, the national popular vote does the trick. But I think that we know that there is something awry with the Electoral College, that it doesn't meet, if you want to use the Supreme Court's terminology, it does not meet current conditions. I also know that states have adopted pacts, and that there is more of a political wave that is happening, where states are seeking to move to the popular vote. So I do think that this is, one of the challenges for our communities is what we have asked people to do to participate. What I described is literally a fraction of it. What people have to do to vote is a lot. And then they have to work and take care of families and do all the other things that we're asking of them. And people are frankly tired. But we know, and what we have seen is what people are willing to do because they believe that this country can be better. And this past year is such a motivation to know that despite the crap that people had to contend with, they showed up and they showed out because they believe in our country and they are willing to do their part. And we have to do our part to support them. We have to educate people about why it matters. I think once people understood what the balance of power meant in the Senate, they were like, I'm showing up on Georgia on January 5th, 2021. Once we do our job of explaining that redistricting matters in your life for the next decade, that when you elect people into office, they are there and they are making decisions about policing, and we lift up examples of where change actually impacts people's lives. I believe that we can encourage people to invest in our systems for not just the key elections where we tell them vote or die, but consistently. Obviously, if we educate ourselves in schools and we understand our history, I feel we should be indebted to the people that came before us to do our part. But I think we need to spend a lot more time on education, on connecting the dots for people. I think we're all become nerds about voting and we get how all these pieces, but we need to do more to make sure people feel invested and that they see the tangible impact of political power on their lives. And I think last year was a shining light amongst a lot of crap thrown at people about what's possible.
And I think, apathy and hopelessness is as dangerous as partisan redistricting. And so getting people involved in the smaller races. Somebody winning for sheriff, somebody winning for solicitor makes a real difference in a community. And so, just keeping the focus on the things that really affect people's lives can also just add light at the end of the tunnel, add hope and a reason to participate in the process. And frankly, if in some of those situations, coming close is almost as exciting as winning. It's important to see the progress and to engage people in the power that they do have in their own lives, so that they can see it and they can feel it. It is kind of contagious once you see it happen, and that's really we need to build up that momentum in even the smallest little places in South Carolina. So we need people to know where in South Carolina has there been population change? Where has there been a lot of people move in, a lot of people move out? That's where redistricting is going to hit. And we're going to get that information into the hands of those communities so they know. they know what's happening to them and how they can participate in that process.
Well, I love the answer to both of those questions. They're very inspiring. And I will make a shameless plug for the rest of our Good Governance series. Event 3 will focus on electoral college reform and looking at the US Senate and specifically the filibuster and the history of the filibuster. And our last event will focus on kind of out of the box voting solutions like ranked choice voting, like jungle primaries. So definitely stay tuned in the series. I promised we would not go past 7:15. So I apologize if there are more questions in the chat. I think this engagement is absolutely incredible. I do want to just make a couple quick announcements. First is, if you want to continue this conversation, please join our book club. We are having a session this Saturday at 1:30. If you haven't read the book, don't worry about it. Please join. We'll have an inclusive conversation around voting rights and based in this great book by Ari Berman, Give Us the Ballot. We also have our second event on redistricting, which was brought up a couple times tonight, in 3 weeks on March 22nd, Monday, 6 o'clock. So please register, join in for that. If you are looking for a recording of this event, if you want to share it, this will be hosted on our Facebook page, and we will also have a separate Good Governance landing page on League of Women Voters website of the Charleston area. So just Google League of Women Voters, Charleston area, and you'll be able to find it. Leah, Lynn, Susan, cannot thank you enough for being here with us tonight. I'm going to put you all on the spot and say, if you have, one more call to action, one word, one sentence for people as they leave this session, what would it be?
I think for me, it would be, don't become cynical. Keep the faith. Keep working at it. If you give up, you're definitely not going to go anywhere. And we need to work together.
And I would say the hope is in the young people. We've got to get them involved and keep them involved and learn from them.
I think to that point, I'm super inspired by the work in Georgia and Michigan and other parts of the country. We can all find someone who is skeptical of the process, who is checked out and doesn't believe, and spend time and energy investing in them and illuminating to them why they have power and why people have worked so hard for so long to deny that of them. And if we bring more of those people into the conversation, I'd rather spend my energy convincing them that they have power and we have power in numbers than trying to persuade people who do have this zero-sum approach. That's how I choose to spend my energy, and I encourage us all to do the same.
Fantastic. Well, thank you all. If we didn't get to your question in the chat, we will do our best to follow up with you after the event with answers. You are going to get an email after this event with all the information on HR1 and H3444 and who to contact and some talking points and some tips. So please keep your eyes open for those emails. Please join us in a couple of weeks. Thank you all. Thank you again, Leah, Lynn, and Susan, and everyone enjoy your Monday evening.